I'm sorry, with the subpoena first?
Because they wanted to,
They being,
I'm sorry, when we was given the subpoena.
Who gave you the subpoena?
presumably an attorney.
Yes,
the prosecutor's
yes, yes.
office. Okay, but when they gave it to you, why didn't you just go serve the subpoena at that time, sir?
Because the concern was that the subpoena would not be complied with, so we wanted to have a search warrant to back up the subpoena. If the subpoena couldn't be complied, we could execute the search warrant right then and there. Because from what I believe is that we wanted the documents forthwith, from best of my recollection, and if we couldn't get the documents forthwith, then we would execute the search warrant.
Very good, go ahead. That's just a procedure. I'm not getting into the search warrant or I'm not getting to the affidavit or search warrant. Go ahead.
Was there a discussion before you execute the search warrant that in fact you were seeking certain sensitive documents that could have been considered work product or privileged information?
I don't think that was never discussed, no.
Did you know he was a lawyer?
Yes, I did,
Did
yes.
you know that he was a lawyer for Mr. Bashara?
Yes.
Okay.
Yes.
And you prepared the affidavit, didn't you?
Yes, I did.
So you wrote in the affidavit what you were looking for.
I'm not getting into the affidavit.
Well, it only goes to his knowledge as to what they were looking for.
As to what he did. Okay, I will allow for that.
All right.
I'm sorry, could you repeat the question again? I'm sorry.
You prepared the affidavit.
Yes, I did.
You were requesting the search warrant.
Before we even go any farther, is there a stipulation that the search warrant was, that the affidavit and a search warrant were valid?
No.
Okay, well, I'm not going into that.
Because, okay, and I'm not either, but I haven't, how could I can't stipulate to a document I haven't seen.
Does he have it? Do you have this?
They haven't given it to me. I've requested it numerous times, and I said I'd like to have it before today's proceeding.
Do you have it, sir?
Judge, it's sealed by court order. Even if we had it, we could not disclose it without violating a court order.
Well, move to unseal it at this time.
You can do that in front of the judge who issued the search warrant. I mean, we don't have the authority to turn up something over. It would be a violation of the court order. We would be in violation and subject to contempt charges.
Right, but they could have moved. They could have moved at any point in time to unseal it, and they're sitting back on that, and they're not doing so, knowing the trial is supposedly next
Don't
week.
worry about the trial.
Judge,
I got the trial.
the
I don't need you to worry about the trial.
The affidavit has nothing to do with the procedure of executing the search warrant.
Very good. Let's move on.
So, you know you're looking for certain writings and papers, correct?
That's correct.
That were prepared by Mr. Bashara?
Yes.
Was there any discussions with you with the numerous prosecutors that you were working with, that there could be some questions and issues regarding the confidentiality, the work product, attorney-client privilege? Did you have any of those conversations?
Judge, but what does this have to do with the execution of the search warrant and his request for nothing?
Sustain. Let's move on. So anyway, what happens when you go over there with the search warrant? How many officers go with you? Yeah.
Probably about 6 or 7.
Okay, and then you go, how are you directed, or where are you directed?
Are you talking about what was the procedure when we got to the house?
Right.
Myself and the captain from Grosse Pointe Park knocked on the front door. When we got to the house, we didn't believe anybody was home at that time, so we knocked on the front door, didn't get an answer. We attempted to check the door, see if it was open. It was open. At that point, we were making entry into the house because we didn't believe there was anybody home to serve the search warrant, or serve the subpoena on, so we were going to serve the search warrant. And that's where we were met with by Mr. Valente.
Okay, go ahead.
So, what you're saying, are you standing by, is it your testimony today that there was only 6 or 7 officers in entirety present there at that time?
Yes.
Okay.
Okay, I'm not going to allow any further us to go farther in it because what you're requesting is to return to this property.
Yes.
Okay, so this is ancillary. Go ahead.
Well, I thought the court wanted to have a hearing, and I'm trying to determine, you know, why it was necessary to seize his property, and why it's necessary to retain his property at this time.
All right, the issue of why it was seized is really up to the court. I mean, we just want to know the procedure of what was done.
Okay.
I'm not going into the validity of that affidavit. That's before another.
Right, I'll go back.
I just want to know the procedure.
Right.
So anyway, you go out there and so then you see Mr. Valenti. Once you see Mr. Valenti, he says, I'm not honoring the search warrant because it's some work product, the subpoena. So then you give him the search warrant?
Yes, ma'am.
And what do you take?
We took any paperwork that was listed with Mr. Bashara's name on it, files, writings.
And where'd you get this from?
It was from the office area and other parts of the house.
You see his newspaper articles?
I believe so.
You see his photographs?
I'm not sure exactly if we received, sees the photographs or not.
Okay. Let me digress just real quickly. You went there, first of all, you were searching his house.
That's wrong.
Okay, very good, let's move on. So then you come, and so everything that had the Mr. Bashira's name on it, you seized it.
Yes,
And
ma'am.
what'd you do when you say you seized it? Put it in boxes?
Put it in boxes.
Did you catalog? When you execute a search warrant, you're supposed to prepare a return, you're supposed to prepare a return, are you not?
Yes.
Okay, and that means that when you're at the location, you're required by statute to categorize and list everything that's taken from the person's house, is that
The
correct?
tabulation is sealed. So there would be nothing left.
Okay. Was there a tabulation done at the house at that time?
No, it was not.
So you violated the statute also by not conducting the tabulation at the house when you were collecting the property,
The
correct?
tabulation doesn't have to be done at the house. We just have
Let's
to
put the
do.
court to the side, let's move on, go ahead. But you didn't do it at the tabulation at the house, is that correct?
No, ma'am.
How many boxes did you take?
I cannot remember offhand.
In excess of 5, 10?
It was probably, could be anywhere between 5 and 10.
Okay, very
Okay,
good.
I just go back for an inquiry that
Yes,
the
sir.
court wanted.
Yes.
When you prepared the affidavit for the search warrant in Mr. Valenti's law office, did you have a discussion with any of the prosecutors as to what judge you should take that to?
No, I did take everything. Are you talking about why did I go to Judge Kenny?
Yes.
I always take everything to Judge Kenny.
Okay. And prior to this date, the 28th,
Yes.
had you ever taken any other search warrants to present them to Judge Hathaway?
We have had prior ones, but that's when Judge Kenny wasn't available.
Okay.
And he instructed us in his stead to go to take him to Judge Michael Hathaway.
On this particular date, when Judge Kenny was not available, and you were aware of the fact that this was a search warrant for an attorney's home, did you contact anyone in the prosecutor's office as to the alternate plan as to whether you should take the search warrant to Judge Hathaway or to someone else? Do you understand the question?
No, because I think you're getting it wrong.
Well, here, let me understand something. When you presented this search warrant and the affidavit to Judge Kenny,
Yes,
you were aware it was for an attorney's home.
yes.
You understand that, is this the first time in all your years that you executed a search warrant in an attorney's home?
Judge, why is that relevant? I object.
Well, I'm allowed, is it, yes or no?
I believe it could be. I can't remember ever.
Okay, all right.
Okay, I'll move on.
Okay.
Judge Kenny, the chief presiding
Yes,
judge,
sir.
recused himself
He did.
because he
From the
knew,
search warrant, just from the search warrant?
from that
is
search
correct?
warrant,
That's just for
For
the search.
Mr. Valenti?
Yes.
because Mr. Valenti was an attorney that he knew, or that Mr. Valenti was an attorney? What was it?
He said that he had handled the Valenti parents'
Divorce.
divorce, and that he thought he could be fair, but he didn't want any appearance of impropriety, so that's why he recused himself,
Okay.
and that's why he asked me to take it to his alternate.
Did he ask you to take it to his alternate?
Yes,
Okay. And did he specifically say take it to Judge Hathaway?
I believe so, yes.
Well, no, don't believe. If you know,
If
you
don't-
say it.
Don't guess if you don't know.
Everything that if Judge Kenny,
Sir,
okay,
listen to the question. I mean, you've been around the block enough. I'm asking you a specific question. When you presented that search warrant and affidavit to Judge Kenny, and he said he recused himself because he had been involved in the Valente divorce, did he tell you, did he direct you to take the search warrant and affidavit to Judge Michael Hathaway? Yes or no, I don't know.
I cannot remember specifically, but that's the exact
Okay.
words he used.
Okay. After he recused himself, did you ever think about calling Mr. Moran or any of the other prosecutors working on this case to ask them for some guidance on what you should do?
Judge, why is this relevant?
Sustain, move on.
When you went to Mr. Valente's home, were the officers in raid gear?
That's not relevant.
It,
How? It's not relevant.
well, it's relevant to the conversation that he had with Mr. Valente inside the house.
I'm not gonna allow it. Go ahead.
So you come into the house, is that correct?
Yes,
Armed with your search warrant,
yes,
and Mr. Valente meets you at some point, correct?
we never broke the threshold. When the door opened up, he was standing right there in the doorway.
The
and
door being the front door, side
The
door?
very front door of the house, right in the middle of the house.
Okay, and you presented him with the subpoena?
Yes,
Did you have that in your hand?
yes.
Did you have the search warrant in your other hand?
I had the search warrant in a folder, and I handed it I said, "I'm here to serve a subpoena on you." And he said, "That's a lot of people to serve a subpoena." And I took the subpoena and I handed it to him. He read it over, and he says, "When do you need this by?" And I said, "We need it right away."
Immediately.
Immediately.
And by the fact he said he needed some time, didn't he?
He said, I cannot comply with this because it would violate the attorney-client privilege.
Okay.
And,
And
go ahead, no, go ahead.
he told you he couldn't comply at that time because it would violate the attorney-client's privilege.
Right.
And then you said, well, then here, we have a search warrant to execute in your house.
Yes.
Okay. And how much time did you give him after you showed him the subpoena and he talked about the privilege? How much time did you give him to comply?
I gave him as long as he could tell me to say he wasn't gonna comply.
30 seconds or less?
Oh, it wasn't that long. It was longer than
Oh,
that.
it wasn't that long? Okay. How long was it?
Well, I mean, we talked about 5 minutes at the door.
All right. After you told him that you were searching the house?
No,
Okay.
that's when I gave him the subpoena.
Okay. So your testimony now is that you gave him 5 minutes.
Something around
So
there.
what did
yeah.
you talk about for those 5
That's
minutes?
not relevant.
All
Move
right.
on.
All right.
Okay, so then let's just get back to it. They're in there, they take everything with Mr. Bashir in their 5 boxes and you seal it up, is that
Yes,
correct?
exactly.
And then what do you do with it?
Everything is transported to the Grosse Pointe Park Police Department.
Okay.
And when you say you took everything that had the name Bashara on it, is that correct?
Absolutely.
You didn't take just these writings and diaries or anything that had a picture of Mr. Bashara, a newspaper article of Mr. Bashara, anything with any property that were in legal files, and you did take legal files, correct?
We took everything that had his name on it,
Okay.
that we could find.
Okay. That wasn't moving. All right. And you boxed everything up
Yes,
and took it to the Grosse Pointe PD?
yes.
Okay. When did you inventory this?
I did not inventory it.
Okay. But it was not inventoried at all at the house, is that correct?
No,
Okay. One further question. Did you write a report?
No.
So when you were a Wayne County Sheriff, you used to write reports, incident reports, when you would do an investigation and execute a search warrant, didn't you? Wouldn't you? Isn't that proper procedure?
No, it depends on what we're gonna be doing. It would be a case-by-case basis on what we're gonna do.
And this is a very important case, wasn't it?
It is.
Probably one of the, besides Kwame cases, probably the biggest case you ever
It's a
had.
very big case. Yes.
All right, go ahead.
All right. Well, good. You never considered preparing a report after you executed the search warrant to document what happened that day and your interaction with Mr. Valente?
No,
Did anyone ever ask you to prepare a memo
No.
or a report?
no.
All right, so and when you
Counsel,
test,
we getting away from
Very
what
good.
he did. What did you box it up and you sealed it?
Yes,
You
ma'am.
transported it to the Grosse Pointe Police and then they transferred it to the prosecutor's office?
Yes,
Okay, fine.
and you don't know what happened with this subpoena?
not offhand, no.
All right, very good. Anything further?
No.
No. Step down.
Thank you, ma'am.
Procedurally, it's my understanding that once that information, the items were seized from Mr. Valente's home, then they were taken to the prosecutor's office?
Eventually, they ended up there, Your Honor. I can just, as an officer of the court, I can tell you that I had a conversation with Detective White and told him to seal everything, put it in a box and seal it, don't tabulate it, don't look at it, don't review it, put it on evidence in Grosse Pointe, and that way, if it becomes an issue in the future, which I knew it would be, then we could then have it preserved and then
Now,
examined.
where is it physically?
Physically, it's in our office, in our locked vault area.
Okay, very good. And it's my understanding that, that Gene Stempien had been, appointed as a master, is that correct?
Yes, Your Honor.
Okay, verbally?
I don't know. I have not seen a written order from Judge Hathaway.
I don't know.
Okay, very good. Now, anything further that you wanted to place on this record?
No,
I do. All we want.
Excuse me? Okay, this is what I'm gonna do. Two things. Number one, the court is going to order that the item seized pursuant, you're gonna get a court, I'm gonna have a furnish order to you. On October 29th, that were initially reviewed by the master, who is, Third Circuit Court of Gene Stempien. Because of the court, the amount of items that were seized and the familiarity that Judge Stempien has with this information, I am going to formally appoint her as the master to review those items, to make that, I want her to make her report made known to me, and then what I'm gonna do is I'm going to do an in-camera inspection of anything that is a work product, and if so, at that point in time, then we will, based on that, I will have the attorneys that come back, and then we will ultimately release the property back to Mr. Valente. That is not an issue.
But we're missing the point, Judge, is that when we met in the prosecutor's office, we divided the material seized into separate boxes. The box that contained information that was possibly work product or privileged, that is the box. That is the box that was sealed, was actually sealed again and provided to the master. There's another box which just involved, and that's the box that we're seeking, and that's the box with just Mr. Valente's files.
Sir,
That,
I plan to review everything to make a determination. If in fact those things were just some personal items of Mr. Valente's, there's no reason that they should not be immediately given back to him. And the other items, there will be a determination made as to whether or not those items can be released. However, what I want to do at this point is we don't know what the master's, first of all, she is now formally appointed. I want to see her findings. Based upon her findings, I now feel that it's proper for me to have a conversation with her, and then I want to do an in-camera inspection. I understand what you said, that there was an agreement that that everything was divided in boxes, and in one box it just had some personal issues. I plan to do this forthwith. I have the order prepared, and I'm going to give everybody a copy. That copy will be made available today or tomorrow. And then I'm gonna contact Jean Stempien to find out if her findings have been made available so that we can get on this forthwith and get Mr. Valenti back his information.
But that information we're requesting is not what something that Judge Stempien reviewed. That's a separate box. We're talking
What
about a
box
box
is
that we've
that?
already, it's a box of files, of legal files, that is separate from what Judge Stempien did.
Okay.
Those are files we've reviewed, those are real estate files and
Okay.
property files that have nothing to do with this case.
Okay,
And
and what
we
the
told,
court is going to is going to find is that any and all material that has nothing to do with this case will be turned over to Mr. Valenti within the next 15 days. And I have an order that will reflect the court's finding, as what I've indicated. Anything further?
Judge, just a housekeeping matter. Physically, the files are in our possession. Does the court in the order, I mean, they're locked up in our file room in the vault. Do you want us to, is part of the order going to be to turn those over to the court for the in-camera inspection, or are you going to wait for the master's report?
From I don't know when that report is going to be due, but I think that the report may have been, I don't know. I'm gonna find out. And let me indicate for the record that, thank you for that. 15 days from the court's receipt of the master's report, those items will be returned over to Mr. Valenti, which I anticipate is not gonna take longer than this month. It will be done expeditiously, I promise you. As a matter of fact, this is what the court is gonna do. Today is what?
18th here.
The 18th. The court is gonna set the next hearing date, March 11th.
Judge, those files that we're talking about, had nothing to do with the
I
master.
made my ruling and that's it, thank you. All right, very good, you'll have a respective order regarding this by tomorrow, my secretary's out. Okay, very good, thank you, good seeing you. Okay, let's get Mr. Bashir, Mr. Bob Bashara, come on. All righty. Very good. Okay, back on the, excuse me, back on the record in the matter of, the people of the state of Michigan versus Bob Bashara. Appearance for the record.
Ms. Lindsay, on behalf of the people of the state of Michigan.
Robert Moran, assistant prosecutor.
Mark Indling on behalf of the people.
Mark Receipt on behalf of Mr. Bashara.
Nancy Schellebring on behalf
Mr.
of Mr.
Bashir,
Bashara.
there's something you want to say to me, and what is that?
Your Honor, I've prepared a letter that I had hoped you would have gotten prior to today, but it's a page-and-a-half letter that the prosecution is reading. I'd like you to just take a minute and read it.
I don't know why I wasn't given the letter first.
Well, I suggested that, Your Honor. I gave it to one of your deputies to bring to
Well, what
you.
the court had indicated for the record is there a deputy available to give me that documentation? No, as a, no.
If you send it directly to the letter, I'll just show it. Okay. Either way.
Okay, very good, thank you. I'm in receipt of this letter. What I am going to do is, the court indicated previously that it was within my purview to appoint counsel for Mr. Bashir. At this time, based on the letter and the desire of Mr. Bashir, I am going to remove the defender's office. I'm going to appoint, David Cripps and Gabby Silver to handle this particular matter. Although there is a request that, they be able to, join in, I just think at this point, I'm gonna remove them. I am going to appoint another attorney, however. I am going to appoint Mr. Bashara 2 attorneys, and that, the next attorney will be forthcoming. But I am going to appoint David Cripps and Gabby Silver. I just believe that at this point in time, with the volume of information and his initial desire to have him to be appointed, that they will be here. I will have them back on March 11th. Yes, Ms. Linda?
Judge, just for the record, I discussed it with counsel and we reviewed the case law. And defendant must waive on his record any appellate issues because according to the case law.
Of 180-day rule?
No. According to the case law dealing with the court's ability to remove attorneys, it says that the only way and the only reason why that a court can remove a defendant's counsel is for a finding of gross negligence. And that is the case law, and that's People v. Arquette, citing Harlan v. United States 387. And I can give the court, but they said these are the only reasons that the court can remove a person's appellate counsel. And specifically, Harlan says merely disagreeing with the conduct of the way an attorney is presenting the case or going about preparing the case is not sufficient. So if the court is in fact going to be removing counsel and giving new counsel, Mr. Bashara must waive on the record now any claim in the appellate arena that this is at some type of error. If we can get that waiver,
Let me see the case law that says that.
I highlighted, in each case it's highlighted.
Is there?
Not object to removing us from the case. There may be issues. You know what I'm saying? Well, what? Yeah. At least, I can't.
Okay, this deals with, I guess, his first case, the Arquette, because I haven't had an opportunity to really review it, with the desire of the defendant to have his own retained attorney.
All of the cases that I've given the court more than one case, and there's a brief, if I can just put on the record.
I think that that's a little obviously different.
Well, can I just?
Okay, go ahead.
Okay. A court may remove a defendant's attorney on the basis of gross negligence,
And
incompetence.
that's Michigan versus Fisher.
People versus Arquette, and that's, and I only have Northwest sites, although you have the actual cases up there that have the Michigan sites. And it's 507 Northwest 2nd, 824. According to the standard set forth in People versus Arquette, defendant's counsel may be removed if it's on the basis of gross negligence, incompetence, physical incapacity,
Okay.
physical incapacity or contumacious conduct. The court in Harlan, the case I just talked about, People versus Harlan versus United States, the trial court may not remove a defendant's counsel merely over a disagreement regarding the conduct of defense counsel. There's also People versus Johnson. It says the court may not arbitrarily or unjustifiably remove the attorney over objection of the defendant and defense counsel. To do so violates the defendant's Sixth Amendment right.
Okay, very good. But here's
Can I
oh, go ahead, I'm sorry.
finish
Go
making
ahead.
the record? The whole basis, and the court has said repeatedly, and the court has said on the record that the court was confident that counsel could do the case. The court indicated in the transcript of January 9th, page 9, lines 11 and 12, the court is familiar with Mr. Preceda, and I know his skill level is above normal and above average, and I know he'll be able to do a good job with this. The last transcript we were here, the court indicated that Mr. Procida and Ms. Shell had stellar attorneys. Furthermore, the last time we were in court, Mr. Bashara himself indicated that he was satisfied with the defender's office.
Okay, now he's indicating that he no longer wants their representation, is that correct? Yes or no?
Yes, ma'am.
Very good, I'm gonna remove Lotta from the case.
Okay, now what I'm asking though is for him to at this point waive on the record any,
Be quiet.
I'm asking him to waive on the record any appellate claim he has in this regard,
Okay.
because it is his choice to do this.
No, this is what I'm going to do. I'm going to ask him a series of questions under oath,
Okay.
and I'm satisfied with that. Raise your right hand. You solemnly swear affirm testimony about to give this matter the truth, the whole truth, nothing but the truth, so help you God.
I do.
Mr. Bashara, you understand that you have the absolute right to have the defender's office represent you, is that correct?
Yes.
From your letter, you indicate to me that you initially wanted, and you did make this reference, that you wanted to have David Cripps and Gabby Silver, who they're a team married, to represent you, is that correct?
Yes, ma'am.
And is my understanding at this time, is that your request?
Yes, it is.
Very good, then I'm gonna remove it.
Also, at this point, can we have him waive on the record any speedy trial claim?
Okay, very good. Now, let me explain that to you. As a result of me getting in a new set of attorneys, you understand, sir, that we're not gonna be able to go to trial in March.
I do understand that. Yes,
Would you?
ma'am. You asked me a
No,
question. I'm
just
sorry.
saying, I wish everyone would stop talking when I'm talking. This is important. I'm trying to make a record. If it's not back over here, it's over here, please. So do you understand that, sir?
Yes, I do.
Okay.
That we're not, I'm sorry, repeat the question, that we're not going to
Okay,
have
right.
a...
We're not going in March.
Yes, ma'am.
There's no way.
I understand
I
that.
have to get them up to speed. There haven't even been, formal motions that have been filed in this matter. The transcript has been received. Moreover, on March 11th, when the court comes back, not only am I going to formally move to put Mr. Cripps and Mrs. Silver on there, I am going to I've been given the right to have another attorney appointed, as well as to appoint or to have supplemental individuals brought on this case to assist the attorneys as far as copying, just doing handiwork. You understand? So that's what I'm going to do. I'm going to do that March 11th. Now, let me go back to this, because this is important. It's my understanding that you want, and I'm going to make this real clear. It's nothing obviously personal with Mr. Procida and Ms. Chanel, is that correct?
That's correct, absolutely.
And you wanted Mr. Cooper, who normally was the lead attorney, is that correct?
I don't know who was the lead attorney, but the three of them,
Right.
yes,
But when he was removed from the case,
yes.
did that make you feel that you were not satisfied with the representation that you were receiving?
It caused me great consternation, yes, ma'am.
It did. And so as a result, now there is a request, do you understand, it's my understanding that you want me to remove the defender's office and add Mr. Cripps and Ms. Silver, is that correct?
That's correct, Your Honor, but if I might put an asterisk to that,
Wait a minute,
Okay.
and the court is also going to appoint another attorney so that there can be ample representation for Mr. Bashara. Now, was it asked what you wanted to there?
well, I just, as a way of transitioning, I would hope that the court would allow Mr. Procida and Michelle to remain on and work with Mr. Cripps and Ms. Silver for a smooth transition with all the material and everything that they have at their
They
office.
can't do that. It's one or the other.
Okay,
You understand?
that's fine, then I do understand.
So based upon that, do you want to relieve the defender's office?
Yes, ma'am.
Okay. And obviously, in that, I am going to give a reasonable time for all of the discovery to be given to them. Do you understand that?
Yes, ma'am.
Which I understand is going to take us some time, but we do have the transcript that is available. What I'm going to do is, on March 11th, when they are formally here, the court is then going to request that any and all discovery that was given to the attorneys, that were given to the defense attorneys, will be provided and be ready for pickup for Mr. Cripps and Ms. Silver, as well as the other attorney that the lawyer, that this court designates. Can that be done?
Well, we gave them a hard drive. If they can return the hard drive to us.
Oh, okay.
And along with any copies and everything that they have made, I think that would be the best way to do it.
I don't want, this is my concern, I don't want to rely on their copies, because if there's something missing, then it's going to be an issue that they're.
Well, that's why we want the hard drive, because everything they got should have been, so we can check what's on the hard drive to make sure that it's up to date.
Judge, and we have the hard drive available, that's fine.
Just give the hard drive back. That's
Yes,
all.
absolutely.
Just keep those notes. I don't want to rely, I don't want something to be missing, and just, they're going to return the hard drive, and then from the hard drive, you can make these other discoveries.
Yes.
You can do that?
Well, yes. Yes.
Okay, and then the transcripts, the court can have them ready on March 11th.
Yes. And the only thing I would like the court to add is the trial date. In addition, we know we're not going to March, but the trial date could be substantially delayed because Mr. Cripps and Ms. Silver have trial scheduled. So there's a possibility that we might not even be going to trial until October or November of this year. So as long as Mr. Bashara knows and he's waiving any claim.
Well,
as it relates
first
to
of
that.
all, he only has to raise 180 days. When?
No,
and-
I'm not talking about 108 days,
Okay,
I'm talking
but-
about the constitutional right
Okay,
to
but-
speedy trial.
Okay, he's waiving that.
Okay.
Okay, is that my understanding?
Yes, Your Honor.
And so you want this done, you understand there may be an opportunity that this case is not gonna go into October or November, that's completely out of question. But that it could be in June or July, or even August.
I do understand that.
Okay, very good. And, let me just redo it. Raise your right hand.
Oh,
Do
me?
you solemnly swear affirm testimony about to give this man the truth, the whole truth, nothing but truth, self you got.
I do, Your Honor.
You have no objection to having, it's your desire at this time to have this court appoint David Cripps and Godby Silver as your attorney. That's
No,
all I say, correct?
I have
Is
no-
that your request?
It is my request.
Okay. Moreover, it's my understanding that as far as the speedy trial and 180-day issue rule, you waive that. Do you understand that?
I do understand it, and I do waive it.
Very good. At this time, the court is going to make the following finding: defendant's waiver is knowing, voluntary, understand, intelligent, and made. Court's going to still accept it. See you March 11th. Good luck to both of you.
Thank you,
See
Judge.
again on another matter.
Thank you.
And back, you know.
Grab your, file.
Is she still up there? I'm sorry.
No, she's gone for the day.
Good day, Your Honor. Good day. Thank you, sir.
You know, I had something, she don't have a double front end. Do you have a legal size? Her printer back there doesn't use front end. I would have to. That's right.